Disney is attempting to dismiss the state lawsuit, the DeSantis-led district lawsuit in state court in Florida. So today we're going to jump right into it and we're going to look at the motion to dismiss, and I am going to give you exactly why this motion to dismiss will fail. No burying the lead here. I am absolutely unequivocal it will fail, but I'm here to tell you why, to explain exactly why it is going to fail and why the mouse is going to be taken to the house in court here in the state of Florida. Well, I'm outside the country right now, but I'm a Florida attorney. If you guys don't know me, Andrew Esquire, Florida attorney. This is the legal mindset. We teach you to be your own judge, and I have been on top of the mouse, or shall we say the rat. And this time, in this case, I think the rat is going to stay caught by the DeSantis-led district. Absolutely 100%. I'm very convinced about that. And I think that this is an attempt that, look, Disney's lawyers have to make. They're obligated to file certain things like a motion to dismiss. And for those that don't understand legal procedure, don't worry. That's what we're here to explain on this channel. This channel is here to educate, entertain, and provide up-to-date, unbiased information based on Florida law, because as a Florida attorney, I know a thing or two about that, particularly as an attorney specializing in special districts and this specific niche of law. So let's get into it with this case that was filed and the motion to dismiss. So this is the state case, and this is courtesy of Deadline was the one who first broke this. This is the version of the motion to dismiss that I have. This was filed by Disney's counsel. So the district did amend its complaint, just making minor changes about a week ago, and they are actually just responding just today, brand new, as to the amended complaint and trying to dismiss that. So what it is there's a preliminary motion. So step one is that one side files a complaint. A complaint is all of the allegations in the lawsuit. So they're saying, hey, we think they did this and this and this, and here's what we want. And in that original lawsuit, which I have pulled up right here, the amended complaint, the district is asking for those development agreements, those restrictive covenants, the things that were done illegally and last minute by Disney. They're asking for the court to invalidate those. So if we look at the prayer for relief section, this is in the district complaint, the amended complaint, you see what they want. That's in the prayer for relief. They're not, it's not a church prayer. It's praying for the court to give them these things. So they want four things. They want, number one, the development agreements to be declared void, unenforceable, or invalid. 2, the restrictive covenants to be declared void, unenforceable, and invalid. 3, to issue an order enjoining Disney, so that means stopping Disney in all actions Disney will take. That's very clear. So let me say that one more time. So enjoining Disney from enforcing the development agreement and restrictive covenants. So right there, from enforcing it, including lawsuits based on enforcement of the development agreement and restrictive covenants. Mind you, just pay attention to that one. Number 3, very important here. And then number 4 is a catch-all. Almost every lawsuit will have this, so you're going to see this when you go through a complaint in any lawsuit out there. Grant such other relief that this court may deem just and proper. Because in the law, we're interested primarily in what is just and what is proper and what is appropriate under the law. So Disney is responding with the motion to dismiss, and this is the first motion they can file. So other than admitting it and trying to get a settlement or trying to come some sort of agreement, they can just go right into motion to dismiss, first preliminary step. And the standard for a motion to dismiss is very, very high. And what do I mean by that? What I mean is the presumption is, when under a motion to dismiss, that everything that the plaintiff says is true. So all of the facts that are alleged by the person who filed the complaint, in this case, the DeSantis-led district, the DeSantis-appointed district, so you have to assume everything they said is true. This is very damning and makes it very hard to get past a motion to dismiss. This is why motion to dismiss, as per general, fail. The majority fail, whether at the state or at the federal level. So this is something that we can, just going into this, expect there's a massive chance for Disney to fail. On top of that, the reasoning they use is so ridiculous and preposterous that it gives them a 0% chance of victory here. But this is something that just we have to know and disclose, and you guys should know when you're looking at motion dismisses in general. So because those presumptions are in their favor, they have to take everything they said and what they're asking for as presumptively okay. And what they're doing here is they're attacking the reasoning for the lawsuit. And they're attacking it on this basis called mutinous. Now, mutinous may sound like a fancy word. It may sound like a legal word, but let me explain it to you. Mutinous means there's no purpose whatsoever to the lawsuit. So their argument is that the district lawsuit against Disney, right, to get rid of the restrictive covenants and the development agreement, that lawsuit is now moot because the Florida Senate through SB 1604 has now done everything. It's invalidated them. It's invalidated the development agreement, and it's invalidated the restrictive covenants. Therefore, there's no need for the lawsuit. There's no need for it at all. That is mutinous. Mutinous means there's no point whatsoever. And that is a super high standard, guys. For a case to actually be moot, there needs to be zero reason whatsoever. And there is plenty of reason. Let me give you two things right here that make it absolutely crystal clear it's not moot. Number one, and the biggest thing, and this is something I believe my good friend Valiant Renegade has also brought up, is that the federal case is still there and unamended. So what do I mean by that? There's two separate cases going on right now. So imagine this, two separate cases. In fact, I'll go full screen for this one. Two separate cases, okay? State case, federal case. And the main basis for the federal case that Disney is bringing against DeSantis and the members of the district is based on the development agreement and the restrictive covenants. So if those aren't there, Disney had five different causes of action. They've got to drop almost all of them. Almost all except for the First Amendment complaints against DeSantis, right? Which it's questionable. They probably don't even have standing to bring those in the first place. But they've got to drop almost everything in that case because their case is entirely based on that. So either they get rid of their case in federal court entirely, or they have to revise their federal complaint. If Disney really believes those development agreements are moot and they're gone and they're invalid, if they truly believe that, then they've got to drop their federal case or amend it severely. They haven't done that yet. So they can't make that argument. They cannot make the argument that, oh, well, the Senate has already invalidated these. That's what they're trying to say. See Senate Bill 1604. They clearly don't believe that. And this is the classic case, particularly with woke corporations. They try to have it both ways. They try to have their cake and eat it too. Well, in this case, they can't do it that way. The court is not going to allow this. They're going to laugh them out of court. They're going to blow this motion to dismiss out of the water. That is going to absolutely be a losing argument because they haven't dropped their federal case. If they really want to do that, they've either got to amend it or drop it. They have not done that. So number one, both point A and B, these are going to be blown out immediately. Now let's go to number two. In alternative, the court should stay this under the priority principle. So there's two arguments here. There's two main arguments here for priority of a federal case over a state case. And that is, for example, if they are filed on the exact same subject matter and the exact same law applies, well, then the federal case would take priority. That's something that is true in the law generally. However, here's the problem, and here's where Disney gets in a lot of trouble. It's not the same law. The law they're arguing in the state case is state law and whether or not the agreements are valid under state law. That's something they actually have to go through. And by the way, another important thing about a judicial finding that these agreements and these covenants are invalid is, what is their federal complaint? Their federal complaint is saying Ron DeSantis is an evil, mean person. And let's invalidate all the acts of Ron DeSantis and the legislature. Let's overturn the Florida legislature. Let's do that. They want to overturn that. So if they're believing that the legislature is evil and biased and, oh my God, these mean Republicans, then they're going to overturn the 1604 bill as well, which overturned the development agreements and the restrictive covenants. You get where I'm going on this? So that would still leave it needing to be interpreted under state law. And if the judge finds that legally, apart from whatever Ron DeSantis said or did, right? Putting that aside, right? Let's ignore everything the Senate said or the legislature said or Ron DeSantis said. Ignoring all of that, under just pure Florida law, what Disney did was illegal, illegitimate, and unenforceable. By the way, that's true. What they did was unenforceable under Florida law. I know this is my area of expertise. What they did is not okay. They failed to provide notice. They failed to follow the statute. They failed to give any consideration. There's multiple reasons why it does not work under Florida law. It's also an illegal delegation of government power. These are all reasons why it doesn't work under the law. Forget the First Amendment. The retaliation thing doesn't matter. It could be let's even say it was retaliation. It still wouldn't matter under Florida law. So that's why this argument that the federal case takes priority in federal law and it's the same thing. No, it's not. It's completely different. State law is completely different. And only in the state case are they arguing proper law. The federal case is just a Disney sham and a Disney delay tactic. It also talks about similar parties and issues. Look, they're not similar parties. That's another problem here as well. They've got Ron DeSantis included when Ron DeSantis has nothing to do with the law at hand and also nothing to do with the case. Really, the proper party is the district. And they try to play this game of, oh, we sued people in their official capacity because that's the same as suing the district. Well, here's the problem. They're putting those bonds at risk. And this is where Fitch and all the other rating agencies, they're going to perk up because they are risking those bonds by suing the district. And they know that that's going to be a significant hit. And also probably the bondholders are going to look at their covenants and say, didn't they say they're not going to do anything to threaten the veracity of these bonds? Because, by the way, DeSantis has come out in a separate article and said, look, one of the reasons why we formed the second district was just to make it absolutely clear that the bonds were going to be transferred to keep the bondholders happy. So DeSantis is doing more to keep the Disney bondholders happy than Disney themselves. So it's actually really hilarious there. And by that, I mean the district bondholders, the people that own the bonds of former Reedy Creek, now the Central Florida Tourism Oversight District, that $1 billion in bonds. So I think both on 1 and 2, they are going to lose this argument entirely. Disney does a very good job of trying to mess around with procedure, and you can see why they win against everyday, normal, average Joes. This is why Disney, when they take Tom, Dick and Harry to court, they typically win because they'll throw out all the procedural fuckery that they can in order to slow a case down, delay it, bring it to a settlement. This is what Disney does. This is their jam. This is throwing spaghetti at the wall and trying to see what sticks. But in this case, the substance matters. Disney is not going to win this little fickle procedural victory here in Florida. It's going to be blown out in the state case because the state judge is going to know exactly what's going on here. Guys, we're going to stay on top of both the federal and the state case on this channel, and I'm going to stay on top of all the business coming from the rat because in this case, they're absolutely caught in this trap. Until next time, guys, take care.